Good afternoon and welcome back to the Maresonix seminar. It's the last seminar of this semester in this series. Welcome everybody joining us remotely and welcome everybody here in the classroom. Just as a reminder, we have here the Maresonix seminar as part of the Materials, Resources and Sustainability class, where with the students in the classroom. And the public can join us remotely, and I see that there are several out there. To give you a quick run of show, I'll introduce in a minute our guest speaker, and thereafter he will give a presentation for about 40 minutes. And thereafter, we will have a short time of discussions at the tables here. Those joining remotely have the option to join a breakout room to discuss the discussion prompts that will be shown on the screen. And then we'll have about 25 minutes for a Q&A, and that will close today's seminar and also the entire seminar series for this spring semester. So with this, it is a great pleasure to introduce Peter Smith. Upon graduating in 2004, Mr. Smith went to work as an associate attorney at the firm of Lukins and Annis in Coeur d'Alene, where he became a partner in 2009. In 2015, Mr. Smith founded Smith and Malek. He was appointed to the Idaho Lottery Commission by Governor Brad Little and served from March 2021 to September 2023. He is a former vice chairman of the Post Falls Urban Renewal Commission. He currently serves as an at-large member of the Idaho State Bar Real Property Law Section and was chair of the Indian Law Section. He also has served as president of the First District Bar Association and has been recognized for pro bono work by the Idaho State Bar, and he currently serves as the president of the North Idaho College Foundation and on several boards of various organizations. In 2023, he was awarded the Idaho State Bar Professionalism Award, and he is now the director of real estate with Fenimore. Please help me welcome Mr. Peter Smith.
Professor Molnar, thank you very much for that great introduction. To move the slides, I assume I just push the arrow button. Is that correct? All right. As Professor Molnar said, I am a mining lawyer here in the state of Idaho. I've been practicing for 21 years, and I'm going to give you a little bit more background while you read the disclaimer that every lawyer has to put on every PowerPoint. Basically, what that says is anything I say you can't rely on, you should assume I'm wrong. How does that sound? Anyway. I have been a real estate lawyer for 21 years. I'm married. I have 3 kids. My daughter, Bella, is a freshman at Montana State University. My other daughter is a sophomore in high school, and she plays soccer and track. And I have a son who's in 4th grade and 10 years old. I'm going to talk to you today a little bit about mining law. And a way to understand mining law, I think, is to go back to the beginning. And I have slides, but I don't like slides with a lot of words on them. So I'm just going to use pictures and then kind of just talk my way through it. So our mining law came from England. And in England, the Crown owns everything but the property. So any minerals the Crown owns, any animals the Crown owns. That's the basis of our jurisdiction here in Idaho and in the United States for mining law, is that the Crown or the federal government owns all of the minerals except for the original 13 colonies. So most of the West was acquired through treaties, wars, and the federal government acquired all of the minerals. Now, in other countries, the minerals owned by the Crown or by the government have a system of exploiting those minerals from the ground that's different than we have in the United States. And I'm going to go through kind of how minerals are owned in the United States. And the number 4 is important here. But in the United States, minerals are real property. They're attached to the ground. So just like if you were to buy a house and get a deed, you can do the same thing with minerals. They're what you call severable, so they can be separated from other parts of the property. In real property class, my first year of law school, they told us about the bundle of sticks, and that's real property. You can take one stick out of the bundle and give it to someone else, And minerals are just like that. They're just one bundle in the stick. The minerals in the United States on federal land are owned by the federal government. Now, federal land in the state of Idaho is owned by the Forest Service and the BLM, and they're managed by those two agencies. And minerals on federal land are held by the federal government. And so there's 4 categories of land within the United States. There's the federal land, the state land, tribal land, then there's private land. So federal land is land owned by the United States government. Most of the West, and this is key to understanding mineral rights, was at one time owned by the federal government before states were put in place. So they acquired all the minerals within the federal land. Next is the state land. Within the states, like Idaho, the minerals are held by the state if the state owns the ground. So they own the minerals and they can do what they want with the minerals. They acquired those minerals typically from the federal government when they became a state. The next is the tribal lands. So tribes are interesting. I represent a number of tribes. They were essentially sovereign nations, as you know. And so when the federal government came west and states were created, they created what they called reservations. And the word reservation is key because what they did is they took all the tribal land and said, well, the tribes are reserving this area. They didn't really have much of a choice, but they reserved certain areas to themselves. In mining law, if you go into a reservation, the tribe, just like the crown, owns the minerals within that reservation. This map just generally shows all the reservations in the United States. Where I live is up north. The Coeur d'Alene tribe has a significant reservation up there, and they would own all the minerals below their land. Then there's private land. Private land was conveyed either from the federal government to people or states. And the way that we call this is when we look at all the chains of title, there's something called a patent, which isn't a patent you get for, an invention that you get, but it's a patent that you get, which is a deed from the federal government signed by the President of the United States. Those patents will typically convey the minerals and the surface rights to an owner. So when you're thinking about land, I want you to divide it into 2 categories for this discussion, 2 sticks. One is the surface and one is the minerals. I mostly work with hard rock minerals, which are minerals you extract from underground. And so of the 4 categories of land, I'm going to tell you about each one of them and how you acquire mineral rights in federal land, state land, tribal land, and private land. So a little bit of history for you. The mining law in the United States was adopted in 1872, but prior to that, there was the California gold rush. Everybody came out west because they wanted to find gold. And when they did that, they needed rules so they didn't end up getting into wars with each other over who got the minerals. Because you would imagine if you're a miner and you're coming out to California, you go find a nice spot where you think there's gold, everybody and their uncle is going to try to come and take that spot from you. So they established a system to avoid having conflict over how to divide up the minerals. And they basically said, hey, you got to go out there and you got to do certain things to show the world that you own that little area of land and you can mine that land. And that's the entire genesis of our mining laws in the United States. Because once we had those systems in place in California, Congress enacted a law in 1872, which has not changed at all since then on how to govern how you get mineral rights in the United States of America. So this is a photograph that I took of a stake in Washington County, Idaho, which is over by Weiser and Cambridge. This stake is how you get a mineral rights or have the right to mine in the state of Idaho. What you do in Idaho is you take a 4-inch by 4-inch stake that's 4 feet tall. And if you go out on federal ground anywhere in the state of Idaho, you take those posts and you put them in 4 corners. 1,500 feet long is the rectangle by 600 feet. It's 20.66 acres. Any one of you as a U.S. citizen can go out at any point in time on any ground that has not been staked and stake your own mining claim. And to keep that mining claim, you have to pay the BLM about $221 every year to maintain that claim. And it's not always been that way, but the law, as you can see in Idaho and across the West, is antiquated. In Canada, if you want to stake a claim, You get on your laptop, you draw the places you want to have your claim at, you hit submit, you own that claim. Here, we have to hire people to go out onto the ground, place those stakes at the corners, and inside that little container is the map showing the claim. So anybody who's walking around out there can see where your claim is exactly located. And you can't put a claim over someone else. That's called claim jumping. So think back to 1872, right? When they were creating the laws that go forward to stake a claim. They wanted people to physically go out onto the ground, put posts or monuments, blaze a tree, which means cut a side onto the tree so you can tell, to show the world that that was your claim. Why? So you didn't get in a fight with someone else over the claim. Now, there's a really interesting real property case, and I'm going to take a divergence here just a little bit. It's called Pearson versus Post. It's the first case you read in real property class in law school. Hopefully, I'm convincing you here today either to become a lawyer or not. That's my goal. But that case, it's something I tell my kids. It's very interesting to me, but probably not to anyone else. But I'm going to tell you anyway because I have the floor. It's about Pearson and Post, and Pearson was out hunting a fox, and he was chasing this fox, and it was along the coast on the East Coast. And he had his hounds and his horses and everything else. And he spent, I don't know, hours and hours pursuing this fox. And the fox just happened to want to hide, and it went into Post's backyard. And Post was just hanging out there having a whiskey, and he decided to shoot the fox. Well, what happens next? Post has the fox. Pearson wants the fox. They get in a lawsuit. Went all the way to the Supreme Court over this dang fox. Who do you think got the fox at the end of the day? The guy who was hunting the fox, who actually shot it and was holding the fox. Goes back to real property law and what we call capture. And that's all we're doing with these posts. And the answer is the guy who was holding the fox kept the fox. Doesn't matter how long you chase it. Doesn't matter how long you're pursuing it. The first one to get it wins. Mining law is based on that. It's the first guy out on the land to post a claim on federal land wins. Now, what's going on right now in the real world? Right now in the real world, last summer out in Washington County, which is just on the west side of our state, there were helicopters, 4, 5, 6 a day, flying 12 hours a day during the daylight, dropping these stakes onto the ground. And then they'd send folks out to find those stakes, pick them up, stand them up on the corners, and create those 20.66 acre rectangle squares for mining claims. Now, why were they doing that? Well, in October of last year, hole number 2 was hit in Idaho. Hole number 2 was a copper find where they drilled down and they found a high concentration in copper, probably some of the highest they'd found in a number of years. What that means is when you have a lot of copper in the ground is you can mine and make money. So who came to Idaho at that point? All the biggest mining companies in the world flooded here. They hired helicopters and stakers, staked thousands of claims. Thousands of acres of land were staked. There are rectangles. If you look at the BLM maps, which is where the records are kept, you will see rectangle after rectangle after rectangle after rectangle, all named. You can name it whatever you want. You can name it after your grandmother. You can name it after your dog. They're all named and they're all spread out. Now, what happens is that's your exclusive area to mine. Now, the first step of this is you have to stake your claim. But before you do that, according to the federal law from 1872, is you have to make a discovery. And a discovery means that you would be able to mine that place and make money. So when you think about hole number 2, when they found the copper, they said, oh, there's enough in the ground here to actually mine and make money. That's a discovery. Now, what do? They flood the entire area because you never know where these veins are going to go and where the good find is going to be. So they stake all their claims. But it's a little nuanced in the law because the discovery is you have to be able to make money off of what you're mining. And they call it the prudent man test. Would a prudent man go out and mine this rectangle where this stake is at? And if he doesn't, or she doesn't, then it's not a discovery. And we have all kinds of interesting things in the law that we can talk about. Does a discovery come and go? Can it come into existence and then fall out of existence? For example, think of lithium. If you follow the lithium price, it goes like this. Like Elon says he's buying or building new cars, it goes way up and then it drops again. The reason is lithium's not scarce. It's almost everywhere, just getting it out of the ground. There's lots of lithium mines, but the price will just go up and down and up and down. So if you have a claim and you've staked it and the price drops, you may not be in a position to mine it. Does your discovery fall out of existence? That's the question. Now, that's a legal question that we haven't answered. And that's how the fights the lawyers start, is I would go to somebody's claim and I'd say, you haven't made a discovery. You haven't found anything that's worth anything. So that ground is then open again for someone else to come stake. So 1872, they adopt this law. Idaho adopts its statute. Under the 1872 statute, it says, hey, you can't just have claims. You can't have claims all across the country and just let them sit. You actually have to work them. You have to do something on them. So every year you got to go out, and the original law said you had to do, I think it was $10 worth of labor a year. And then you had to sign a document that said, yes, I did that. That went on until the mid-1990s, if you can believe it. People would go out to their claims and do work. And eventually it got up to $100 a year, and then it got up to $200 a year. And you can still do that. You can still go out and do $200 worth of work on your claim to keep it. And there are people that do that. They go out and they say they do $200 worth of work. And you don't have to do it on all your claims. You can do it on one and then attribute it across the group of claims because you're kind of working, the area. Then Congress got smart and they said, wait a second, all these people are basically just filing this document and getting away. They're not paying us anything for all these claims. That seems a little weird. So what'd they do? They passed a statute that said, instead of doing the labor, you can pay us. And it started out, you pay us $100 a year per claim, and you don't have to go out there and do that work. So today it's $221 and everybody just pays the fee. So if you have 1,000 claims or 20,000 claims, you can think about you're writing a huge check every single year to keep all of these claims in existence. So those are the federal claims. Now, other states, the Crown owns, like Canada, they call it the Crown, owns the minerals, and they have a royalty. A royalty is a payment you make when you mine. So if you mine $1 million and you make $100,000 off that mine, you may pay 5% to the government as a royalty. In the United States, on federal ground, there is no royalty. Once you pay your $200 a year per claim, you don't owe the federal government anything else. You own that claim, you can mine it for as long as you keep that claim, you don't owe them anything. And that's been a big debate as we look at mining law in the federal government of whether or not we should have a royalty system. Some years ago, they severed oil and gas to make it a leasing system. You lease the oil and gas, which seems like an odd concept, right? Till you get it out of the ground, you're leasing it, you pay a royalty. With the minerals, we don't. And Congress has debated this almost every year since 1872 on how to change this law related to federal ground. So in summary, federal ground is any one of you that are U.S. citizen or any U.S. company can go out to any place on the Forest Service ground or BLM ground, find your 20.66 acres, carry your stakes up there, put them in the ground, attach your notice, which is in that little can there, so everybody knows it's yours and can look at the map. Take your notice, go to the recorder's office, record that, and you own that claim. Of course, you got to pay your $221 to the BLM every year too to keep it. But that'll be your claim to mine, to explore, to dig around on as much as you want. So Idaho has been a hotbed right now for this. We have had thousands and thousands of claims staked. What'll happen with those claims? Who knows? We'll get a little bit what happens next after you do this. Now I want to tell you a little bit about how you acquire minerals in state ground. So if you're on state ground, it's a totally different system. States were a little smarter than, well, depends on your perspective. Some say the states were a little smarter than the federal government. Some say they weren't. States have a leasing system. So what you do at the state, and we're doing this right now, I mean, as we speak, there are leases being drafted and being put up for auction. So what you do is you go out on the ground and you file a document with the Idaho Department of Lands. It says, hey, I'm going to go look for something. And what that does, it gives you the right to go onto that ground and nobody else can go onto it while you have that document. You have 2 years to go out and dig around and figure out if you want to lease. If you want to lease, then you fill out a whole nother set of documents, you submit those, and you get a lease from the state. And what that gives you the right to do is mine whatever acreage you're leasing. Before you get your lease, it goes to a public auction. And one of these was just held in McCall. 20,000 acres went up for auction from the Idaho Department of Lands for a mineral lease. And the Department of Land sets a minimum amount you have to bid. I think that one was in the $20,000 range or something like that, to acquire a lease for 20 years, be able to mine ground. With the state, though, remember I talked about the royalty? The royalty comes from the word crown, royalty. It all fits together when you start thinking about it. But the royalty is about 5% of your net smelter. So if you make any money, you pay 5% of that amount to the state. And that's negotiable and it needs to be changed, and different minerals require different amounts of royalty. But the state system is completely different than the federal system. And the debate that goes on in Congress is whether or not the state system should be adopted at the federal level. Because right now the feds get zero once you pay your fees for your claims and you start mining. The other category of land is the tribal lands. So I explained how tribes came into existence, right? They were here from time immemorial. And I represent tribes that have litigated over, I live on Lake Coeur d'Alene up north. The Coeur d'Alene tribe always asserted that they owned a portion of the lake, the southern third of the lake. In 1990, there was a lawsuit that went all the way to the U.S. Supreme Court. The Supreme Court said, yes, the tribe did acquire the southern third of the lake in the agreement it signed with the United States of America before Idaho became a state. So tribes, when they acquired their reservations, they acquired all the mineral rights. And if you want to go into tribal land and you want to mine, you have to negotiate with the applicable government, which is the tribal government. So most tribes have a leasing system of some kind. Some aren't open to mining at all, but those that are, you have to go talk to them. You don't deal anything with staking. Like I talked about at the federal ground, you don't deal with leasing with the state. You deal entirely with the tribal ground. I have never negotiated any documents or any agreements with tribal land mining, but they own within their reservation, they own all the minerals as long as their treaty granted it to them. And if you think back to all this, I like to put it into context, right? The United States of America was rushing out west, right? They wanted to get all the way to the coast and they wanted people to go, right? So what did they do? They tried to encourage people to go west. And as they were going west, they ran into the Indians. The Indians weren't so happy about all of us trampling all over their land and setting up cabins and forts and everything else, right? And basically they went to war. And the Coeur d'Alene tribe is one where General Sherman wrote back and said, if you don't make a treaty with these guys, they're going to fight to the death because they're not going to back down. So the treaty was their agreement. Hey, we'll take this land, but we get everything in it because we've owned it since time immemorial, is what they say. So that's kind of the tribal history and why they own their mineral rights. Now, private land. Private land is, for a miner, is the best because you own the surface and you own the minerals and you can do pretty much anything you want on that land as long as you comply with the Clean Water Act and the Clean Air Act and other permits, state regulations regarding pollution. You don't have to deal with the federal government. You don't have to deal with the state government other than the permitting side of getting those certain permits. So state land is the best. I'm going to go back to the history of this. Where did this private land come from with the minerals? Well, when the federal government said, we want people to go west, they adopted a couple of acts. They said, one, if you go out there and you just build your cabin, stake out your land, we'll give you a patent or a deed to that land so you own it. And in the beginning, they were giving the land with the minerals. In 1916, Congress got smart and said, wait, we're giving away all our minerals. We may want to keep those because when they're mined, we want to own them and be able to divvy those up. We don't want to give them to all these homesteaders. And they passed this thing called the Stock Raising Act, which said if you go out, you get 640 acres, but you do not own your minerals. The next slide I put in here, my daughter insisted on it because it fits the context of what we're going to talk about. But so far, what we've talked about is federal land, federal government owns the surface and the minerals, right? You go out and you plant your stakes on those. You can go to Home Depot today and buy your 4 stakes and do that. State land's a little more difficult. You got to go out and look, and then you got to apply for a lease. Then you have to go to an auction. Then you got to negotiate the lease, and then you got to sign it, and then you can go mine. And tribal land, good luck. You have to go to the tribal ordinances and figure out if they'll let you mine there. Private land is the best. You pretty much do whatever you want on that land because you own it. as long as you comply with all the environmental regulations that go along with mining on that ground. Got it? So here's so this is me at Hyde Park about a year, well, probably longer than that. I went for a mountain bike ride and I got a banana split. My daughter thought that was pretty cool, that I was so happy about my banana split. She took a picture of me. So I'm going to talk to you about split estates. Okay, so that's why it's banana split. Get it? Yep. Anyway, split estates. Split estate means the ground on top that you walk on is owned by one person and the minerals underneath that are owned by someone else. Now, this is where it gets a lot of fun, and this is where lawyers spend a lot of time working, because you got to track down these different splits in ownership and how do you get rights to it. So I'm going to start out again just talking about the federal ground first. If it's a split estate, it's a stock raising property. That homesteader came out west in, let's say, 1920, found 640 acres, wrote a letter back to DC and said, I'm living here. My fences are up. It's my land. Send me my deed. And the president signs the patent and sends it back out to them, and they take it to the county and they record it, and you own that 640 acres. But when they did that, the United States said, but wait, we're not giving you that bundle of that one stick, the minerals underneath. Now, what can any of you do on stock raising land in the state of Idaho? Some of it which is in Washington County. Well, what you do is you find out it's stock raising and you're like, wait, you only own the surface. The minerals are still there and I want to get to those. So you go on the internet and you get what's called a noidle, a notice of intent to locate. You fill it out, you put it in the mail and you mail it to the property owner, and it says, I'm coming out in 30 days and I'm going to be staking on your property and creating my claims on your land that you live on. We've done this a number of times. The reactions we get are very mixed, but most of them are, go pound sand. This is my land, you're not coming onto my land and doing that. Because a lot of owners, when nobody's interested in your land, you kind of forget. Well, that homesteader who came out here in 1920, he didn't get the whole bundle of sticks, he was missing one. And that means that you can mine that property, you could build a mine on it, as long as your mine is reasonable, which is Congress's favorite word for lawyers to fight over. You can mine as long as you're not harming that property unreasonably. So that's one issue with the split estate, is you got to look at your title commitment, and your title insurance company will tell you or tell you not whether or not somebody else owns your minerals. But that's happening right now too, as these noidles are going out and the property owners are saying, whoa, 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 I don't want a bunch of dudes trucking around my land looking to put stakes up. But they do acquire those claims on the split estate by doing that. The other is that we've encountered is private owner owns the minerals. The state of Idaho owns the surface. So when that happens, you have to send in a notice to the state you're going out, because it's their surface land, right? For example, it may be land where they have hunting ground, for example, and there's elk running around. Here come the miners, right, who own the minerals. Minerals are a dominant estate. And in the legal world, all that means is they trump everything else. Because if you own minerals and you couldn't walk on the surface, it does you no good. So minerals trump everything else. So if the state owns the surface and you own the minerals, you can go out and mine on that ground, as long as you comply with all the state regulations. But you can go out and mine that. Then you got private, so they get split that way. You get surface owner, private mineral owner. This happens a lot in oil and gas down in Texas. All of a sudden, somebody's putting a gas well on your property because they own the rights to those, what's the oil and gas or minerals. So these are the split estates. I've never seen a split estate with state or federal then state, but I've seen it with state on the surface and federal underneath, which means you give them a noidle, just like you would anybody else, that document saying, hey, I'm coming out in 30 days to stake my claim, and you go out on the state ground and you stake that claim and you own it. So split estates are where lawyers spend a lot of time, because you have to track down all these different elements. Now, I've covered all the different estates, right? And I talked to you about the bundle of sticks and what minerals are. They're one of the sticks. So what can you do with this stick? If you own the mineral right, you can do a lot of things with it. You can lease it, you can sell it, you can borrow against it, you can give it away, And the only way you can do that, and how you track all that, you would think you'd go to the federal government with a federal claim, right? And you file some document with them and it says, I own it, and then you own it. That would be the easy way. Well, the BLM decided, or the federal government in 1872 decided, we don't really want to manage who owns the mineral rights. We want to keep track of it, so you have to file it with us. And if you don't, you lose it. But we don't want to keep track of it. That's all kept track of by the county. So your county recorder has all the deeds and all the records and all the leases for minerals. So I get somebody calling me up and say, hey, I own this mineral right. I want onto the BLM. It's in my name. And I say, well, that doesn't mean anything. The BLM doesn't tell you whether or not you own something. Well, what do I have to do? Well, you got to go to the county. If you go to a county like Lamhi County, you got to drive to that county recorder because they don't put any of their records online. And you got to sit in there and find the big books and look through and figure out first, go all the way back to, what did I say, the patent, right? This is the one the president signed. Who did that go to? Went to John Smith. Then John Smith conveyed it to so-and-so. Then you got to get from so-and-so to so-and-so. And you track that all the way down to your owner to make sure they own it. And that's all done in the county records. And I just filed a lawsuit that we just finished where one of those deeds was missing. And it was put in a drawer because they were going to give it to the person who was getting the minerals after he paid $350. They stuck it in a vault in a bank in Weiser, Idaho, and the bank burned down. So 60 years later, we're looking around for this deed saying, okay, we have a gap in our title, right? Which doesn't seem like a big deal. We own it today. Everything's there except for one deed. Well, did that deed get delivered to someone that's now sitting in some drawer somewhere? And what happens when the mine is open? The mine's producing hundreds of millions of dollars a year. You can bet somebody with that lost deed is going to show up and say, I'm either going to make your life miserable or you're going to pay me. Which is what we as title lawyers do all day long. We sit there and we track these split estates all the way through, or even the title to the claims. Now, I talked about there's two ways you can own a claim, right? There's a patented claim. That's you own it, private property, the whole thing. The other one is this staking process, which is an unpatented claim, where you have to pay all the money. Those you have to track both in the county and the BLM, because the BLM just says, oh, we think somebody owns it, but we don't really know. But the county record will tell you. And many times people forget to convey them. It'll be owned 4 owners ago, and your guy's saying, I own it. You're like, well, got to go find some people to sign some deeds because they never finished the process. So that's kind of the overall mineral ownership in the United States. You have 4 categories of land. Each one is slightly different on how minerals are conveyed and owned. And all of them keep mining lawyers very employed as we go through and trying to track these things down. Now, I'm going to talk to you a little bit about opening a mine and what that means. And I'm not going to get into all the statutes and regulations unless you guys want a doctoral course in it. But there are about 14 federal regulations and agencies that are involved in permitting a mine. So you found your claim. Let's just say you got an unpatented claim, you staked it. Your stakes have been out there, you've been paying your $220 a year, and now you want to go actually open the mine. First, you need about $20 billion to do that. But assuming you have that, then you have to wait about 29 years to get your permit. So to go from I found it and something's here that's actually profitable to turning the mine and actually starting to operate it, take you about 29 years of processing through the permits. I'm going to talk to you just about one of the statutes that's involved, and it's called NEPA, the National Environmental Protection Act, which says basically, I'll give you the short version because I don't fully understand it myself. It basically says if the federal government does anything on federal ground or anywhere else, they have to produce a document that says they're doing what's best for the environment. Now, that law was adopted in 1970 and it sat just kind of pretty static. I mean, we had a lot of lawsuits over it, but everybody kind of understood the lay of the land. And then we had this president named Donald Trump come into office and it threw it all into haywire. And now we're trying to figure out what any of this means. And I'm going to try to explain it at a very high level so you can think about it on the questions that you face as a voter and being educated on mining. Should we be doing it this way? right? So NEPA is what they call a procedural statute. What that means is it lays out the rules. It says, if you're going to open a mine, you've got to look at this, this, and this. And you've got to do these certain documents. You got to do an environmental assessment, which says, do I need to do more looking into the environment? The goal is to make it so that man and nature live together and we're not destroying each other. Well, we pretty much destroy nature, but it doesn't really destroy us very often, though it does occasionally. Anyway, NEPA says we're supposed to live in harmony. And it's got all these beautiful words like that, live in harmony and, do what's reasonable and do what's the best. And we all kind of understood what that was. And it was what you called a procedural statute. So you'd say, okay, if I did A, then good. If I did B, then I'm good. If I did C, I'm good. And did D. It didn't really tell you the end result. It didn't say this mine in this place should be permitted. It just said you have to go through all these steps. And each one of those steps gave an opportunity for someone to sue. And that's why you see so much litigation. Is because if you say, well, it doesn't really affect the rare hummingbird, and somebody else says, yes, it does, and then the courts need to see if you followed all the steps to reach the conclusion that you did as an agency. So that's why it was so much lawsuits. And when Trump came in and he said, listen, the courts have way too much power. They're issuing injunctions. They shouldn't be able to do that. We need to trim this back. They're looking much too broadly on how it affects the environment. We need to trim this back and make it really simple. We just need to get things done. That was his motto, right? And so it kind of shrunk really quick. And he was a little late to the game on his first term. He didn't really get moving as quickly as I think he's doing now. And so by the time he got his rules in place, Joe Biden got elected. Joe Biden came in and said, no, wait, all that's BS. And he changed NEPA again. So NEPA, I said, was procedural. And that's just a fancy word. You follow the steps. If you check A, B, and C, then we're pretty much good. That's what it said. He said, no. NEPA is actually a statute that tells you what to do. It's what they call substantive. And these are the things you need to look at. You need to look at the whole world. You need to look at people who have been affected unfairly by prior projects. It's called environmental justice. You need to look at that. And you need to look at greenhouse gases. So, and not only look at it for the city of Boise or the county of Ada, you need to look at it for the entire world. So imagine trying to get a permit for a mine somewhere and meet all those, what are they? The terms are open-ended and anyone can argue any point. I think I could probably divide you guys up in the room and say, argue to me why this project affects the butterflies in Costa Rica, and you tell me why it doesn't. And you guys could come up with great arguments on one to the other. So NEPA was thrown into this whole new world of substance. What is the right result? And other things to consider, all by rule. There was no statute passed. It was just by rule. Then we did pass the Fiscal Responsibility Act, and it went in and said, okay, NEPA needs to be trimmed back, and we need to make sure they have to get their documents done within 150 days, and they need to be limited to a certain number of pages, and did all that. Now we're back to Trump. So we had Trump shrink it, Biden expand it. Trump's now going to cut it back down. And what Trump says is you look at a project. You say your project is in the city of Boise. You really just need to look at the city of Boise. You don't need to consider what it does to the Amazon. You don't need to consider what it does to Washington, Oregon, California. We want you to really focus. And the policy debate, which Congress it can't get itself to get to, is whether or not that's the right way to approach it. How do we approach when we look at the environment in a project? How broadly should we look? Should we look at what's called the cascading events? So you build this today, right? Then tomorrow next to it goes another one. Mine number one goes in, then mine number two. Is it foreseeable another mine will be built? Probably. Do you have to compound what that does to the environment to approve the first one? Trump would say no, Biden would say yes. So we're in a state of, when you're talking to lawyers about how to navigate opening a mine, we're in a state of absolute chaos trying to figure out what the law should be. And who gets to make these decisions? Judges. Judges that were trained like me as a lawyer. My undergrad degree was an international business degree. The only reason I got that degree is because I went to Costa Rica for a year and taught school. That was the qualification for the international. I did take all the business courses, but that was my qualification. And then I become a lawyer, which is 3 years of, well, the first year you try to study for the LSAT and memorize all these weird logical problems they make you take to get into law school, and then you read books. I know nothing about the environment. And if I'm a judge, I'm faced with these questions of how broadly do I look? And Congress isn't doing anything, so that means the judges have to do it, which means, are they the right people? And how should we approach a mine or another project? How broadly should we look? That's your hurdle in opening a mine. Now, mining itself, it's pretty simple. This is the Kennecott mine, and you can see this is down near Salt Lake, I believe. That's, one of those massive dump trucks there. And this is a copper mine. So I told you about hole number 2, right? Which had the certain percentage that everybody got excited about. The world went crazy. I was at the Idaho Mining Association in October, and it went nuts. Like, the stock of the company that found it went through the roof. Everybody, that's all they wanted to talk about. Hercules, Hercules, Hercules. Amazing find, right? This is what in well, they haven't started the permit process. So we haven't started the 29 years yet. This is what it'll look like. And every ton or 2,000 pounds of dirt that comes out, they may find 5% of it will be, 2% will be copper, and that's profitable. And when you have a mine open like this, your only deal is don't pollute the environment, right? That's it. You got to follow all the rules to keep it open. And then we want to talk about, just briefly, closing a mine. And I found this picture on the internet. What do we want to do when a mine's done? My goal would be to put it back to exactly the place or as close as you can to what it was before, right? We need what's taken out of the ground, and I'm sure you guys have talked a lot about that. I deal in a legal realm, not a world policy realm, but I'm being told that we need these things to come out of the ground and that the world around us is changing. And if we don't do it for ourselves, somebody will do it for us or hold us hostage until we do something to get what we need. But when we close a mine, we need to make sure we clean it up. Now, mining has a horrible record of this. I come from North Idaho. There's a place called Silver Valley, if you're familiar with it. It had massive silver mines, probably the biggest, I think it is still the biggest producer of silver ever in the world. The lead and other things they put into the Coeur d'Alene River was atrocious. When you're mining, you got stuff, right? You have dirt you have to deal with. You got other chemicals you have to deal with. Their solution back in the early 1900s put it in the river. It went down the river and it went into the lake. Now, Coeur d'Alene Lake isn't a part of any kind of environmental disaster zone. They've created what's called the box, which is a Superfund site up there. Superfund just means taxpayers pay to clean it up. They created a box to clean up this area. And the Coeur d'Alene Lake, though, if you stir up the bottom, it'll make you really sick. A lot of heavy metals are sitting on the bottom of that. So we have a horrible record in the mining industry of not doing what's right. Now, the miners I talked to today, they understand you can't leave it like they did. And you can't fault them, really. They really somewhat didn't know. But it's a major issue, and it's one that we have to face, is how do we make a company that did that clean it up to be like that? Because companies, what do? They go away. Poof, they're gone. File for bankruptcy, you got no money. And then who's stuck with the bill? All of us in this room. So as policy, we have to adopt bonds and reclamation, which means put it back the way it was, and trying to figure out how to close a mine. And all those things, as we're looking at the sphere of mining law, all come into place. So we started out today, and I'm going to end so you guys can think about if there's anything interesting that I said. You started out with the crown, right? Owns everything. King of England or the Queen of England owned all the sheep and all the deer and everything else, unless you owned one of them, and owned all the minerals. Came over to the United States and said, we don't have a crown, so we'll just make it the federal government. As they came west, the feds acquired all the minerals. You can go out and stake your claim on federal ground, open your mine, if you can get through the 3 steps I just talked about. And then you got to close it someday when it's done. The state land, you got to get your lease. If you own it in private, you're doing really well. But that's kind of the overview of mining law. There's a lot of nuance that comes in. There's a lot more permitting requirements. There's a lot more detail. But in the United States of America, we have kind of set up a system where, at least on federal ground, you can get a claim and you don't pay anything after you have it. Is that the right way to go? We've adopted statutes that tell us we need to look at the environment, but how closely and how broadly do we go when we're looking at those impacts? And then finally, when we close, who's going to pay to put it back the way it was, and how do we make sure they do that? So those are all things that we're working our way through as a country, but then from a legal standpoint, How do we apply these statutes that are written by Congress to make sure that what they intended is accomplished? So I think that's all I have as far as pictures. I think you got
how property owners had a certain degree of like agency when it came to not letting someone who's like made their claim or staked their claim destroy anything important. Do you feel like that's like they have enough agency and enough power to stop somebody from messing up their land? I also wonder, like, if you hire an expert to go like investigate minerals on your land to see if they're good, is there anything stopping that investigator from telling you there's nothing there, turning around, and then just like staking the claim themselves on your land?
So I'm going to repeat the question as best I can with people online. But the first is, are there enough protection for surface owners in a split estate? A split estate is where the minerals are owned by say, the federal government, and you own the surface, and then you get your noidal, which is that notice of intent to locate in the mail that says somebody's coming out, and then they start building a mine, right? And what protections do you have? Those protections are driven by statutes that were drafted in 1916. So are there enough protections? You can go and read them for yourself, but I would say they're very bare bones. And what they like to use in Congress, and what we lawyers sometimes like and sometimes hate, is the word reasonable. And that's pretty much how it falls, is it reasonable? Are the protections that the miner's taking, they obviously can't probably destroy your house unless the biggest gold nugget in the world is sitting there and they want to get to it. But they just need to be reasonable and use reasonable mining tactics that don't disturb the surface to the minimum necessary to get to what they need to get to. What that means is different in every case, which is why there's lawyers and there's courts and there's litigation, because then you get into those battles. And the second part of your question, and I've forgotten it already because I started talking about split estates and I started thinking about a banana split, but what was the second part?
So thought you had like resources on your property and you hired an expert. Like, is there anything stopping that expert from just turning around after telling you there's nothing on it but staking a claim for themselves?
Yeah, so the question was, you hire an expert, say a geologist, to go out on your property and look for something, and he knows it's a split estate. So you want to stake your own ground, right? You're like, hey, I want to stake this, so I own it. You don't know, and he finds something, he says, oh, you got nothing, then he leaves, and then files a noidal on you and then locates it. Well, the 30 days gives you an opportunity to jump in there. That's one thing. The other thing is he's committed fraud. So he's basically told you a lie, and no court in the country is going to uphold that and let him keep it, because you're going to be able to say, look, I just hired this person and then he came out and restaked my ground. I would definitely have done that, right? And well, as lawyers, we say, well, get a good contract, blah, 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 those things. But no, I think you would definitely have a claim to be able to protect your mineral rights from the guy that is trying to snake them from you. Has it happened? I'm sure it has.
Yeah, oh, this might be long-winded. This is like a really like your opinion type question. So I guess in today's political atmosphere, it feels like things are moving very, very quickly, and it also feels like we get these bills that are just massive. They cover so many wide-ranging topics. In your experience in litigating things, do you feel like newer legislation is more difficult to litigate because it's more open-ended, or do you think it's pretty much similar to old school stuff? And also, do you think litigation is getting more and more like, is there more litigation per an issue than what there was in the past? Like, is that kind of trending upwards as well, or how like now?
So the question was, under modern law, is it getting more or less, is it getting easier to litigate cases because the law is clear, or have we kind of left it the way it was, or is it getting worse? I would say, the bills are massive, right? So, and you have experts that are writing the bills. They're called lobbyists. And so they're paid a lot of money to put the language into the bills that fit what they want to do. And depending on the interest, sometimes they'll write it broadly so that you have more fighting room. And other times they'll write it very narrowly, so there's very little to fight over, right? So if you look at a bill and you see the word reasonable in there, you're kind of pitching a fight. But if it tells you exactly what you need to do in 1, 2, and 3, it makes it clear. I don't think Congress does a good job of drafting legislation. I think what they preferred to do over the last, I've only been alive 47 years, so I'm going to categorize this by 25, is it appears as if they don't really want to do the hard work. So what they do is they pass legislation that says, we want to do this, A, and then they say, hey, agency, go draft a whole bunch of regulations to accomplish this. So they create what's called enabling legislation, and they pitch it down to them. So I think in some ways it's strategic that they want to create more litigation in some cases because litigation is expensive and you can weed out your competition if they get into a lawsuit with you, right? So I think they've kind of, I don't know if it's intentional or not, but I would say just the breadth of it, we're probably seeing, and if they can get it passed, it's usually somewhat decent, but it all depends on the intent, I think. It goes back to what Congress wanted. So, did you have a second part to that question?
Ajay, we got a question online?
Yeah. The question is regarding fourth bottom question, the stakeholders have different perspectives. So yes, we need to change, but what happens as an example when toxic spill happens to the Salmon River, kills all the fish and then starts killing fish and other wildlife downstream.
What happens? Well, there's liability that goes to the company or the person that made the spill. So they need to pay to fix the problem. The problem that you have is sometimes on these catastrophic spills, there's just nobody left to pay the money. They just run out and there's nobody left to go after. And you may have heard of CERCLA, which is the environmental law in the United States. It says you have to clean up every disaster you had. And I think you had Trouts Unlimited come in and talk about, well, if we touch a project, we own CERCLA liability, right? There's legislation that's going through, and I think it may have already passed, about Good Samaritan. You can come in and clean something up. Because what happens is it's like stibnite up in Idaho here. You have a disaster, right? Or the river got cut off, so the fish can't get up and down. And it's a mess. And we got a company that wants to come in and fix it, but do they want to touch it? They touch it, they own it. And they don't want to own that problem. I mean, so when there is a catastrophic spill, as a society, we have to plan for, okay, how are we going to pay for that? And who's going to pay for it? And like in the Silver Valley, there was nobody left. The only person left to clean that up was the taxpayer. And so as a society, we have to decide, are we willing to take those risks? And how do we mitigate them so we stop them from happening? But if it does, if the catastrophic happens, who should pay for it? And is society ready to step up to clean that up? Because often the costs are so huge that there's nobody left other than the government.
I've got a question. I'm thinking that it's a little bit of a weird question, but should there be a mining law school for environmental reasons, for environmental issues, kind of cover this stuff? Or this is the second part I was thinking about is, could there be like a full-time amicus brief or friend of the court type of situation for an environmental studies person to go out there and research the issue, front to back for the mine, the whole 60-year lifespan of the mine?
So the first part of the question was, should there be a law school dedicated to kind of teaching lawyers about the environmental impacts in mining law so they can make the arguments that are clear and convince a court? And then second, should there be a special body out there like an expert that is always available to help courts make these decisions, which are very hard, very scientifically based, right? The first part of that, probably the issue becomes is, does anybody want to take it, and can law schools make money doing that, right? And the second is, do we already have it? So as a lawyer, right, I would say I have a limited skill set, right? I'm trained to advocate. I'm trained to read statutes. I'm trained to try to figure out what Congress said. And when I hit the reasonable question, what do? I go hire the expert and I pay them to come in and help me. And our system was designed beautifully by our founding fathers. It's adversarial. So if my expert says A, their expert comes in and says B. And then the court usually gets, during that process, it takes a long time, but the court gets really, really good information because you've got not only the parties coming in, but sometimes you have third parties coming in saying, no, they're both wrong, and this is our expert. And the more voices you have in a dispute where they're really going at it and really just telling this guy is completely wrong and this guy's completely right, usually courts then can distill it down and get to a certain point. Now, what do judges come to that question with? They come with a perspective. They come with, which way should this go? Certain judges of certain political leanings may say, I want to interpret reasonable to be this way because it fits my worldview. And that's where you get, when you read about the New York Times and Wall Street Journal about the judges and how they approach a problem, right? Conservative versus liberal, and what's their end result. Because when you get into these gray areas, you can kind of get to the end and then work your way backwards, especially when you have all the experts coming in, because you can pick expert A and said, I think that expert's better because it fits my worldview. Now, do they do that? There are leanings on how they interpret the law that reach those conclusions. But I think the process overall really does kind of weed that out and probably makes it unnecessary to have somebody just sitting there, because then that person's accountable to someone, right? And who would that be? Donald Trump or Joe Biden? Or so they're going to write their amicus briefs a certain way. So I think the system as it's designed, let's battle it out and let the chips fall where they may.
So, like, if you're, I forget what you said exactly, but when it comes to having to deal with the counties, you're trying to get the mineral rights and it spans over 2 counties, how does that really, like, say it's over like Canyon and Ada County, is it like if it's 67% in Ada, then Ada supersedes Canyon, or how is it like?
So this happens because you stake your rectangle, right? 20.66 acres, and you record in both. So you do your notice of claim for county here, and you just show your whole rectangle, and you show the county line, you go record it in Ada County, then you run down to Canyon County and record that. And you have 90 days to do that in the state of Idaho, and then you got to file that with the BLM as well, and that'll cover those.
Say a perfect split half and half, and Canyon and Ada, would you claim all 26 in both counties or 15.3?
I would, and so it's 20.66, sorry. Yeah, but yeah, if you're 10.33 on each side, I would do both counties again. I would, yeah, you cover, because you don't want to lose a claim. I mean, it's $221 plus a couple $100 for the person who put the stakes out. You're not going to risk it. You're going to record that thing everywhere you possibly can.
So they
say reasonably, usually there's a precedent that gets set by a court or like a test that's set. Has there been one, or do you see like the Supreme Court ruling on precedent protect the owners of the land?
So you're asking about, so specifically about the noidal, so you got split estate U on the surface and there's a minor coming in, what's reasonable? There has been precedent, but because it's so fact specific, what we try to do as lawyers is say, what's the case that's closest to where I'm at? And then if I'm arguing for the mineral person, I'm saying this one's different and this is why. And I can come up with 5 reasons on why it's different, right? Your trees were less thick, or your house was different, or the sun set differently there. I don't know. You need to make up the reason. Then the other side says the opposite. So you can't really apply a blanket rule and say reasonable is the same in each case unless you're dealing with the exact same case over again. And that's where the word reasonable gets into the litigation, because you can always come up with a good argument, plausible argument, one way or the other. And then the judge sits there and says, okay, which one do I think is the correct one in their experience and looking at all the facts? And then there's usually an appeal and that court looks at it. So it's reasonable is your classic, let's go to trial and have a judge decide it.
So Ian, and then
I'm not sure if this has any relation to like split states and such, but does eminent domain kind of fall in there anywhere where that kind of, is that like in there, in the fold, like how the government maybe goes about trying to take land? You see that all in line? Does the government come in and say, hey, you know, we have this house, but we really need this for national security reasons, we're going to make mine care, that kind of thing? And is that based on mineral rights versus land rights versus?
Not yet. I've never seen that. You know, you're talking like, you know, there's eminent domain cases more recently from the US Supreme Court, kind of when cities could exercise it, and the Supreme Court kind of pulled them back. I think a conservative court would say we don't like the government getting involved in taking private property. Now, when you overlay that with a national security concern, for example, we need antimony to make bullets, and China has all the antimony, and we need to have this property that has whatever on it to do that. I think that's a whole nother ball of wax that I don't think we've faced since maybe World War II.
I still know that kind of.
It can, obviously, the government always has that power, that taking power with just compensation. They just rightfully so exercise it very rarely, because that's what makes the United States of America the leading economy for other countries, is because when you come here, you know the rules. and you're not going to lose your mind like Barrick Gold did in Africa. They're not going to take it from you because they won't. They probably could, but they won't.
It was interesting to me when it was brought up, like whatever regional, somebody wants to mine, what's reasonable, where that kind of falls in. That's kind of like taking me if I don't really want it to, this is the problem.
Ooh, that's a good question. So you asked, so if there's a split estate and I own the surface and you own the minerals, and they come in and mine and they have to take my house out, isn't that a taking, right? Well, it's Pearson versus Post. It's the fox. The guy who caught the fox keeps the fox. He caught the minerals. Minerals are always the dominant estate. So if you come in and say, well, I bought this property, I didn't know that there may be a mine here, which you probably didn't. The law from the beginning said, you don't own that, and you're always owning it subject to that risk, which means from the law's perspective, you paid less for it, right?
So it's not a
Correct. There's nothing to take back because you never had it.
Yeah, I mean,
if you like stake a claim, like go and it's like federal for like 10, 15 years and you want to buy that land, do you have any like leverage with that since you can stake that claim for so long?
So the question is, if you stake a claim on federal land and then you occupy it and use it for a certain period of time, say 20 years, can you own it? It used to be, so first of all, you cannot adversely possess from the crown or the state or the federal government. It's impossible to take land from them. You can only take it from another private party. So that's out the window. It used to be that you could apply for a patent and you'd send all your paperwork back to DC and you get that deed signed by the president, sent to you, and then you would own it. Congress changed the rule and said they're not, well, the statute still says patents can be issued, but the agencies in Congress have said, we're not doing any more patents. There's no more patented claims coming out of the federal government anymore. They've stopped. They put a moratorium on it. And so you can never acquire fee simple ownership of the entire bundle of sticks. You will just have that mineral, which is still the dominant estate. So you can go out and mine it as long as you can do all, we talked about opening a mine, but as long as you can meet all those, you still own that stick. So it's as good as ownership in a way, but you don't have that full bundle. It rarely, I think I've had this question. I think we researched it and it was very rare. Only if there was like a trade. So BLM really wanted some piece to put in a puzzle and then they were going to trade you. But that's very rare at this point for them to divest themselves of land.
so in the states where split estates aren't possible, is this in what can like the state and or federal government do for the private property that they all was founded on the property?
So you asked in the states where a split estate isn't possible? It's illegal to have a split estate? So I'm an Idaho lawyer, so I'm not familiar with those other states on which ones are make it illegal to have a split estate. I'm trying to think. So the original 13 colonies play under a totally different rule because they were viewed as kind of their own countries. That's why we have the equal footing clause. And so the minerals on those states are all state owned. As you go west, you get a lot more federal land. Like look at Nevada, is it 91% federal? I mean, that was because what treaty was it we acquired Nevada? The Spanish. I mean, we had some treaty where we acquired all that land. So the federal government owned it. They've owned it since the Spanish king owned it. And before that, God owned it. So they have the chain of title. They got the fox. So, you know, you hear a lot of people talk, take federal lands back. And I always say, well, I go back to my stupid fox case and I say, well, who had the fox? I mean, God created the planet, supposedly. Then you have all the stuff that came down from there. And at some point, the federal government bought it from either the French or the Spanish. So they owned it. So then kind of a slam dunk case. It's pretty much over. But on split estate where you couldn't have a split estate, I think, you know, with the bundle of sticks, I can't think of it anywhere where you couldn't do that. I think you can always sever those rights. It goes back to Old English law.
Early in your presentation, you're talking about tribal land. You kind of said something effective. Good luck to any mining company that tries to find that. I was wondering, have you been involved or know of any successful ventures in tribal land or mining company?
I've never worked on one, and I can't say in Idaho if I know of any. I would anticipate that the reason I said good luck is from a legal perspective, the laws are going to be all adopted by the tribes. So what you need to do is go look at their laws. So from my perspective, I can't tell you what hoops you have to jump through. So you have to go look at what they've adopted. Trying to think if I mean, there has to be cases, and I would imagine their system's very similar to the state system with a royalty or a joint venture. So you can get more complicated in mining transactions. It doesn't have to be just a royalty. You can do a joint venture. So I come in and I say, I want to mine, and you say, okay, yeah, we can do that. We're going to own it together 50-50. And you're going to put in the $50 million to mine it. And I'm going to give you the right to do it. And then if the profits come out, we get it together. I would imagine those are kind of the scenarios with the tribes, because Indian tribes are very sophisticated businesses at this point. They understand what assets they have and how to maximize their return. And if they're sitting on a mineral claim, they're going to treat it just like a state and want to make sure that they're getting the revenue from that. They're not going to treat it like the federal government does, where they say, as long as you pay me my $221 a year, I'm good to go.
Folks, we got probably time for one more. Going once. Going twice. Dr. Mulner, any last words? All right. That is true. So, folks, this is for folks online. Thank you for listening in this spring. Thank you, Mr. Smith. For folks online, thank you for listening in all semester. We hope to see you back in 8 months' time. For those here, thank you for your patience and for great questions. And please, all of you, join me in thanking Mr. Smith for ending us on a really strong note.